New inheritance law. I hope everybody has heard it, but for April 1st, April Fool's Day 2014, we have a new inheritance law. And there are some differences. And the fact that we have a new inheritance law does not mean that the old law is not of importance. Yes, it remains of importance because we have many estates with persons who passed away before April 1st, 2014. And the old law still dictates how the inheritance is handled for those estates. So when we talk about new inheritance law, we're talking about those estates that, of those persons who pass away starting from April 1st, 2014. Now, main differences. Well, some of it's a bit academic, a bit boring, less group of heirs. This one is very important. Substitution allowed in all the groups. Substitution, I don't know if anybody remembers, I mentioned it earlier. Substitution means I have an heir, a child. Let me see, me, I have a child, but when I pass away, the child has predeceased me. That child had children. Automatically, by substitution, those children replace my deceased child. That's substitution. And substitution is in all the groups. It applies. The entire inheritance law is based on we need the assets to go down the generations. But there are certain alarm bells that go off that at least we need to hear when we're talking about substitution, because the moment we disclaim an estate, so a family member passed away, I could be an heir. I was appointed in the will, and my parents pass away. I'm one of the children, and I say, nope, I hereby refuse the inheritance. Then, maybe without me knowing, my children will get my part of the estate. And sometimes that's desirable because that's what I want. I would like for the estate to go straight to them. Sometimes that's undesirable. I've had those situations as well, where there's a group of heirs and the intention is that a part of that group stays with the estate, another part already had received properties in the past. So that's very, very important when, to watch out when you're planning to disclaim or refuse an inheritance, the consequence. And also disinheriting an heir. I have 12 children, 11 of them are lovely, but there's this one, can't tell you what happened, terrible. And I definitely don't want this child to inherit from me. So I can disinherit the child. It could be that we haven't spoken in 30 years. If I don't mention specifically in the will, I disinherit this child and his or her descendants, I have a problem potentially. At least I'm dead. The others will have a problem. Then these grandchildren from this that I may have not seen in the last 20, 30 years as well, suddenly pop up and say, hey, we're here to claim our father's or our mother's part in the estate. So I'm just saying it, so I put it in red because it's very important. One of the main differences between the old law and new law, and I was and I'm still very excited about it, thank you, Parliament, is the abolishment of the legitimate portion. Now you really have full control of your estate. Under the old civil code, it was difficult almost impossible to disinherit children. If you disinherited one or more children, they had a right to still claim a certain percentage of your estate. We call that the legitimate portion. But under the new civil code, I can disinherit these children, and they cannot come back and claim a share in my estate. Practically the only tool I can think of that they might still have is try to prove that I was mentally ill when I disinherited him or her. That's why I still add 2 witnesses. I like that. So that's a biggie. Then another big one is for the marriage situation, whereby the surviving spouse position has been strengthened. So in comparison to the previous, the old civil code, and of course there's always a comma and a but and unless, you know, that's with every regulation. But under certain circumstances, the surviving spouse position has been strengthened in such a way that you have to give you an example, a husband and a wife and 3 children, all born from the same marriage. I'm so sorry, but men tend to pass away before women. I don't know how that happens. So the husband passed away. Now, based on new law, the surviving wife gets everything, automatically. Vap. Again, there's always a comma somewhere, but let's just talk broad lines. Everything goes to the surviving spouse, under the obligation to also pay all the debts of the estate. So you can get all the good and the bad. The children are not disinherited. The children still get a claim on their, in this case, mother. That claim is that 1/4 share they have in Papa's estate. Because remember, wife, 3 children, each an equal share. So these children still have each individually that 25% claim, but that claim is purely a cash claim, financial claim. So you cannot say, I would like the chair and the table and the car and the generator. No. It's a financial claim that that they have against their mother. But that claim is put in the freezer. The kids are put in the waiting room. That's how I've heard it explained before. They can only claim it if the mother goes bankrupt, because why would you treat a creditor in a bankruptcy better than your own children? So yes, children, mama goes bankrupt, please, come, claim. And situation of her death, then the children can claim it. In a last will, you can increase that list. You could say, well, they can also claim it back if mom remarries, or if mom remarries without a prenuptial agreement. Those are examples that you sometimes see in wills. I'm going to skip quite quickly. Under the new law, there's also a difference between short marriage and long marriages. So that's another topic again. The law also grants different rights, other rights to children, spouse, and or a concubine. You can have a situation where the spouse and second life partner have kind of similar claims in the estate. So those are things that, need to be at least, I would say, arranged beforehand, how to deal with it. But yes, there are certain rights granted. Another change is a declaration of inheritance. I don't know if many of you know of the term declaration of inheritance, verklaring van erfrecht. It's a document, it boils down to a legal opinion that a notary issues that is commonly requested by banks, insurance companies, who want to be sure that they're dealing with the correct persons and that they're distributing the policy to the correct, not only correct persons, the correct amounts. So they will demand from the heirs. Jake goes to the insurance company and says, I'm one of the heirs as mentioned on the policy. Yeah. And then the insurance company says, go to the notary, bring me your declaration of inheritance. The declaration of inheritance, and banks do that also. Please don't make the mistake of thinking that and/or accounts will not be frozen. They will be frozen. Some people have been given the advice, oh, you should have an and/or account. So if your partner passes away, then at least you can continue on. No, it will be frozen. It's a contractual matter, and to my experience, most, if not all, banks do that. So that means, that's why I also advise people, please make sure you have your own private account, have a little money there, because a declaration of inheritance is not something that I can shake out of my sleeve in a very short period of time. We depend on information from third parties, certain instances. And as long as the instances are on St. Martin, okay, relatively easy. But if you have people with ties to Dominican Republic, Aruba, United States, you can imagine the waiting time on the right documentation increases. So if you need to be able to survive, have a bank account, separate bank account, so you can pay your bills and eat and drink, because it's a reality. A little bit more about the legal division. So the protection, the stronger position that the spouse has in the new law has a name. We translate it, the laws are in Dutch, but we translate it to legal division. And the intention is for the surviving spouse to have an uninterrupted continuation of life. That's the motivation. That indeed, as our Prime Minister mentioned, the children are not saying, oh, this is mine now, let's sell it, I need the money. And it replaces, not 100%, but it replaces what was known on the old civil code, and some of you may still have a will with such an arrangement that was known as, well, translated parental estate division, or in Dutch, ouderlijke boedeverdeling. Those wills are still valid because the transitional law still respects those type of clauses. Those are clauses where parents have drafted a will protecting each other, very much alike to the legal division. There is a condition, though. The legal division doesn't apply to every situation. It only applies in the estate of a deceased who left behind a spouse and 2 or more children who are all also children of the surviving spouse. So, husband, wife, husband has the 3 children. That is a typical example of the legal division being applicable unless you deviate by last will. That husband that passed away, wife gets everything, children are in the waiting room, so to speak. It doesn't matter if mom has children from before. That's okay. They don't participate in the estate, they're not heirs to daddy. They will only participate in the estate of their mother once she passes away. So there also you see, some people say, but wait a second. You're saying that what I built up these assets, is going to go to my wife. You mean to say it's going to go to the stepchildren? And for some people that's fine, but some people say, no, I wanted to stay within the family. And then you have to make arrangements in a will. I explained this one already, so I'm going to pass over. These are the conditions for the legal division, the consequences. And then I'm at my last slide, the Declaration of Inheritance, which I also touched on. So it's a deed pertaining to the deceased, the estate, and the heir. So a conclusion, a legal conclusion is drawn in a notarial deed. What is also available if an executor was appointed in a last will is what they call a declaration of executorship. An executor, depending on what type, the executor, let me call it the standard, executor has the right to go to the bank to tell the bank, okay, I need to pay these bills. Has the right to tell the bank, you know what, we need to transfer the funds to an account in the name of the children, etc., etc. What do you need it for? I mentioned that already. The process, well, when it comes to estate work and division partition, that's how it starts. Somebody passed away, there are bills, and then the children go to the bank and say, hey, there are these bills, they need to be paid. And the bank says, sorry, can't help you. You need, sometimes it's called a letter, but declaration of inheritance from the notary. And that's how a lot of people end up at the notary office's doors with the question, can you please assist me with the declaration of inheritance? The process, part of the process is we need to prove who are the heirs, so we need official documentation, family trees from census, not a beautiful family tree that you made in Excel or whatever nice. It helps, but we need it officially confirmed, of course. And then there's the Central Testament Registry that needs to also confirm to us what, according to their registry, is the last will. And then you have those situations where people have lived different places during their lifetime, so you have to request it in different places. In short, my advice is if you have questions, contact your notary office. Ask your questions. It doesn't mean that you may need a will. I always say it's a matter of information, just like with prenuptial agreements. I'm not telling anybody they need a prenuptial agreement, but when you make the decision of getting married, you need to be informed. At least know the consequence. You cannot come and cry by me later. And I'm going to conclude because I'm sure there are some questions. So thank you very much for the attention.